going to give everybody a minute to about a minute and a half in the remaining time here to give some key takeaways of what they want to leave the audience with. And we would like to do it in the order that you spoke. So we're going to turn to John Blattner first. John, do you have some final thoughts for the audience?
My key point is that it's important to play a good defense when you start branding. Make sure you know what trademark rights other people have, and make sure that the mark you're planning to use doesn't step on anybody else's toes. Thanks.
Thank you very much, John Blattner. Bernard Mattson, take a minute and a half, and give us some key takeaways, if you would.
Yeah, I'll take less than that, Sal. Again, if you have a trademark registered, that's the good news. It's also the bad news. You have to properly use it. You have to enforce your rights to keep those rights. We talked about the goodwill and the value of intangible assets. A trademark can be the most valuable asset a company has, and so it makes sense to take the care to properly use it and then enforce your rights so you keep them. And the other thing is, simple thing of a cease and desist letter. That's one of the simplest, easiest things, and not very expensive ways to enforce your rights, and people do pay attention when an attorney sends a letter.
Thank you, Mr. Mattson. Christina Champagnere, some key takeaways for our audience?
Of course. If, despite John's best advice, you got sued or are suing someone, you'll probably at some point consider a survey to evaluate perception that consumers have, potential confusion. And my advice to you is consider also a choice experiment to evaluate whether that confusion actually has any impact on the choices consumers make, and such a study could also serve as input to damages.
Thank you, Christina. David Dusky, some key takeaways?
You know, as I mentioned, there are a variety of measures of damages for trademark infringement. More generally, defendant's profits, plaintiff's actual damages, or a reasonable royalty. If you're in a position of trying to calculate trademark infringement damages, you should be aware of what you need to do as the trademark owner to prove those damages, depending on which measure you proceed with, and what your responsibilities are under the law, and what measure would probably best fit the circumstances that surround your case. The two probably most prevalent are defendant's profits, which Michael touched extensively on, and also plaintiff's actual damages, which more often than not are calculated as the lost profit that the trademark owner suffered as a result of the infringement.
Thank you very much, David Dusky. And Michael Einhorn, would you like to give us some of your closing comments?
Well, blowing that by was sure an effort here, so I do refer you to my paper because it is intended to back up everything I said and hopefully use as a reference. Please share with other people. In conclusion, plaintiffs can win on liability, but they can miss remedies entirely, not unpredictably here. So financial remediation is not guaranteed. When it comes to actual damages, as Mr. Dusky suggested, you can recover actual damages through lost sales or licensing income or lost franchise fees, but they're kind of difficult to prove. The plaintiff's burdens can be quite substantial here trying to prove any one of these categories, so the plaintiff may be left sort of with saying, well, we can win this thing, but I can't prove actual damages. Which brings in the other horse, which is disgorgement of defendant profits, which are allowable by themselves only as a matter of equity, although they are sometimes extended as a matter of law to represent actual damages as well. That depends. But it's an important strategy to recognize the potential to take this from an equity matter to a law matter and get trial by jury. Disgorgement sometimes can be very practical for the plaintiff because it is not only is it a remedy in equity, it can be something that's relatively easy for the plaintiff to prove. The plaintiff has to prove revenues. That's it. That's the plaintiff's burden. After that, everything shifts to the defendant to work the defendant's way out of it. That includes proving costs, which can be a kind of difficult thing, and then also proving an apportionment technique, which can get much more difficult. So an infringing defendant can be in a bit of trouble if they get into the mat on the remediation case, through remediation through disgorgement, because the defendant burdens are so onerous. I think that's a critical thing in recognizing where the court is going to go and what the outcome is going to be if you wind up there. Equities matter. Economic analysis is clearly useful in the presentation of equity. That includes, of course, competitive harm, the potential for new markets, the general reputation effects. All these things are critical matters when winning or losing any dollars on the equity scoreboard. I would say also that, as I've seen, that the use of a weak mark, like a fanciful mark, sometimes can hurt you in equity, sometimes it won't, and the proper use of due diligence in the use of a trademark, of someone else's trademark, sometimes but not all the time, is a matter that's going to hurt you in equity. Again, what Thomas McCarthy first described as a confusing melange of principles is in fact entirely right. That's what we've got, and that's what we have to work with. It's all decided by courts, and the courts really don't make an entirely good job of lining up with each other.